Here is something that almost never happens in American law. The Supreme Court decides a case, interprets the Constitution, and strikes down an act of Congress, and the country responds not by living with it, not by waiting for the court to change its mind, but by amending the Constitution specifically to erase that decision. It has happened only a handful of times in the whole of American history. The 16th Amendment is the clearest example, and it is the one with the largest consequences. In 1895, the Supreme Court held the federal income tax unconstitutional. In 1913, the Constitution was amended to make it constitutional. Everything about how the modern federal government is funded runs through that reversal. So the question for this primer is what that reversal actually accomplished, and it is narrower than most people assume. The 16th Amendment did not create the power to tax income. Congress already had a general power to lay and collect taxes and had taxed income before. What the amendment did was remove one specific procedural obstacle that the court had found in the way. One obstacle in one sentence, and the court's first interpretation of the amendment said so explicitly, in terms that surprise people who read the amendment as a grant of new power. This is Do It for the Kess Law. Doctrine Deep Dives, Season 0, the amendments one at a time, one sharpest gap each. Today, the 16th. To understand any of this, you have to understand the obstacle, and it comes from the original Constitution, not from the amendment. Article 1 divides federal taxes into categories and treats them differently. Some taxes, called direct taxes, must be apportioned among the states according to population. Others, indirect taxes, need only be uniform across the country. Apportionment by population sounds fair until you try to do it. It means that if a state has 10% of the country's people, it must produce exactly 10% of the revenue from that tax, regardless of how much wealth or income is actually in that state. So a poor, populous state would owe the same share as a rich one of the same size, and the tax rate inside each state would have to be adjusted up or down to hit its quota. For a tax on income, that is not merely inconvenient, it is close to unworkable. And it is worth asking why apportionment was there at all, because the reason is uncomfortable and it explains the shape of everything after. The direct tax apportionment rule was part of the founding compromise over slavery. Representation in the House and direct taxation were tied to the same population count, and that count included enslaved people at 3/5 of their number. Linking taxation to representation was meant to discipline the incentive to inflate population figures for one purpose while deflating them for the other. So the clause that made a national income tax constitutionally awkward in 1895 was drafted a century earlier to solve an entirely different problem, one that had ceased to exist after the Civil War. That is worth remembering. Constitutional machinery outlives its purpose and keeps operating on questions nobody designed it for, which meant that if a tax on income counted as a direct tax, a national income tax at a single uniform rate was effectively impossible, and for most of the 19th century everyone assumed it did not count. Congress had levied an income tax during the Civil War. It had been collected for years, and the Supreme Court had upheld it against exactly this challenge. The question looked settled. Then in 1894, Congress enacted a peacetime income tax aimed at higher incomes in a period of considerable argument about wealth and inequality. It was challenged almost immediately, and the court did something nobody had priced in. It changed the answer. The case is Pollock versus Farmers Loan and Trust Company, and it is unusual enough procedurally to be worth a moment. It was decided twice in 1895, because the first decision left the central question open and the court granted a rehearing. In the first decision, the court held that a tax on income derived from real estate was in substance a tax on the real estate itself, and therefore a direct tax requiring apportionment. On rehearing, it went further, extending the same reasoning to income from personal property, including stocks and bonds. And having struck out those pieces, the court concluded that what remained could not stand on its own because the whole scheme had been enacted as an integrated plan. The result was that the entire income tax fell. Sit with the reasoning because it is what the amendment was written to undo. The court's move was to look through the tax to its source. A tax on rent is really a tax on the land producing the rent. A tax on dividends is really a tax on the stock producing the dividends, and taxes on land and personal property were understood to be direct taxes requiring apportionment. So income was not being treated as its own thing. It was being treated as a stand-in for the property underneath it, and it inherited that property's constitutional category. That is a coherent argument. It is also one the court had declined to adopt for 30 years, which is why the decision landed as a genuine shock rather than a clarification. The decision was also close, and its closeness matters. The rehearing came down 5-4. One vote on a question the court had answered the other way for 3 decades, determining whether the federal government could tax income, and the dissents were unusually sharp. They argued that the majority had abandoned settled understanding, that the direct tax category had always been read narrowly, and that the court had involved itself in a question of fiscal policy that belonged to Congress. When we say the country responded by amending the Constitution, it is worth remembering that 4 justices had already said the majority was wrong. The amendment did not overturn a unanimous or even a comfortable holding. It resolved a disagreement the court itself had not resolved convincingly. The practical consequence was severe and it was structural. Without an income tax, federal revenue depended overwhelmingly on tariffs and excises, taxes on goods coming into the country and on specific products inside it. Those taxes fall hardest on people who spend most of what they earn, which is to say the poor, and they are largely invisible in the price of things. So the effect of the decision was to lock the federal government into a revenue system that was regressive by design, and to remove the one instrument capable of reaching accumulated wealth. That is why the reaction was not merely legal. The income tax question became a central political issue for the next 15 years, and it did not go away. There was an intermediate step worth knowing, because it shows how the pressure built. In 1909, facing renewed demands for an income tax, Congress did two things at once. It enacted a tax on corporate income, structured as an excise on the privilege of doing business in corporate form, rather than as a tax on income directly, which was designed to survive Pollock, and it simultaneously proposed the 16th Amendment to the states. That pairing tells you where things stood. Congress was working around the decision with careful drafting while also moving to eliminate it entirely. The amendment was ratified in February of 1913, and Congress enacted an income tax later that same year. Now the text, which is one sentence and does exactly one thing. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Every clause after the first is aimed at Pollock. From whatever source derived answers the court's move of looking through income to its source. It does not matter whether the income comes from land, from stock, or from wages. Without apportionment removes the requirement the court had imposed. Without regard to any census or enumeration removes the population-based machinery that made apportionment work. It is a surgical repair. It names the obstacle and deletes it. The ratification itself is worth a moment, because it did not look inevitable at the time. The amendment was proposed in 1909 and ratified in February of 1913. Which is about 3.5 years. That is unremarkable by the standards of this season, faster than most and far slower than the 26th. What is notable is who supported it. The proposal came from a Congress in which many members expected the amendment to fail in the states, and some supported sending it precisely because they thought it would die there and take the pressure off. It did not die. Enough states ratified, including many that had little prospect of paying much income tax, and the amendment that some had backed as a safe gesture became part of the Constitution. And here is the part that surprises people, which is how the Supreme Court read the amendment when it first got the chance. In 1916, in Brushaber versus Union Pacific Railroad, the court considered a challenge to the new income tax. It could have said the amendment granted Congress a new and distinct power to tax income. It said close to the opposite. The court read the amendment as not conferring any new taxing power at all, but rather as forbidding the income tax from being taken out of the category of indirect taxation to which it inherently belonged, and placed in the direct category by looking at the source of the income. In other words, the amendment did not give Congress a power. It corrected a misclassification. That framing has consequences, and it is why this episode is not really about taxes. If the amendment granted a new power, then the scope of that power would be the question, and the answer would come from parsing the amendment's words. If instead the amendment merely restored a classification, then the underlying taxing power is the original one from Article 1, and the amendment simply cleared away an obstruction. The court took the second view, which means that the modern federal income tax rests on the original Constitution's taxing power, with the 16th Amendment operating as a repair to how that power is categorized rather than as its source. A companion case decided weeks later, Stanton versus Baltic Mining Company, said much the same thing. So what is the gap here? It is not the usual one for this show. There is no grand promise quietly narrowed by doctrine. The gap in the 16th Amendment is between how enormous its consequences are and how small its actual legal content is. One sentence, doing one job, removing an apportionment requirement from one category of tax. And on the far side of that sentence sits essentially the entire modern federal government. Social insurance, the military at its current scale, the interstate highway system, federal support for education and medicine, the administrative state, all of it is funded predominantly by the income tax that this sentence made practical. A procedural fix with civilizational consequences. And there is a second, sharper way to put it, which is about what the amendment reveals about constitutional structure. The Constitution's most consequential provisions are frequently not the ones that sound consequential. The 16th Amendment does not contain a stirring principle. It contains a classification rule about tax apportionment, but classification rules determine what is possible. Before 1913, a federal government of the size and shape we now have was not merely politically unlikely, it was fiscally unreachable, because the revenue instrument that could fund it was constitutionally obstructed. Change the classification and a range of possible governments changes with it. That is not a promise being narrowed, it is a technical rule turning out to be load-bearing for everything above it. There is a subtlety in the Brushaber holding worth drawing out because it is easy to state it too simply. Saying the amendment conferred no new power does not mean the amendment did nothing. It means the amendment worked by removing a constraint rather than by adding an authority. The taxing power in Article 1 was always broad enough. What the amendment fixed was a rule about how one exercise of that power had to be structured. That distinction has real consequences for how challenges get framed. A litigant cannot argue that a particular tax exceeds the 16th Amendment because the amendment is not the source of the power. They must argue it exceeds the taxing power itself, which is a much harder argument to make. The amendment closed a door by making it irrelevant rather than by locking it. It is also worth being precise about what the amendment did not do because a great deal of confusion attaches to it. It does not define income. That word is doing enormous work, and the amendment leaves it entirely to interpretation, which is where a century of tax jurisprudence lives. It does not set rates or brackets or exemptions. Every one of those is ordinary legislation, changeable by any Congress, and it does not make the income tax mandatory. Congress could repeal it tomorrow by statute. The amendment removes an obstacle to a power it does not require the power to be used. So almost everything people argue about when they argue about income tax is statutory, not constitutional. The constitutional question was settled in 1913 and has stayed settled. There is one strand of argument that keeps resurfacing and deserves a direct answer, because this show is about accuracy. A persistent line of claims holds that the 16th Amendment was never properly ratified, usually pointing to variations in punctuation or capitalization among the state ratification documents. Courts have considered these arguments and rejected them uniformly. The reasoning tracks what we saw in the episode on women's suffrage. Ratification is certified by the appropriate federal officer, and that certification is treated as conclusive. Minor textual variations in state instruments do not unmake a ratification. That is not a close question in the courts, and it has not been for a very long time. It is worth naming precisely so that anyone who encounters the claim knows what the actual legal answer is. It is also worth naming what the amendment made politically possible, because that is the part with the longest reach. Before 1913, the federal government's revenue came mostly from tariffs, which meant that federal fiscal policy and trade policy were the same conversation. Raising revenue meant raising tariffs, and raising tariffs meant a fight about protection and about which regions bore the cost. The income tax decoupled those two things. After 1913, the government could raise revenue without touching trade policy at all, and trade policy could be debated on its own terms. That is an enormous structural change, and it is almost never mentioned. Two of the most contested areas of national policy stopped being mechanically chained together because of one sentence about apportionment. Step back and look at what kind of event this was, because it is genuinely rare. Amendments that exist specifically to reverse a Supreme Court decision can be counted on one hand. The 11th Amendment reversed a decision allowing a state to be sued by a citizen of another state. The 14th Citizenship Clause reversed a decision holding that people of African descent could not be citizens. The 26th, as we covered, responded to a decision that split the voting age between federal and state elections, and the 16th reversed Pollock. That is the mechanism the Constitution provides for disagreeing with the court, not defiance, not evasion, but amendment. It is deliberately hard, and it is used rarely, but it exists, and the 16th is proof that it works. Which raises a question worth sitting with, given how much of this season has been about doctrine moving under fixed text. In most of our episodes, the court reads a provision one way and then another, and the country lives with whatever the current reading is. The text does not change, the interpretation does, and the people affected have no direct recourse. Pollock is the case where that pattern broke. The court gave a reading, the country decided the reading was wrong, and the country changed the text rather than waiting for the court to change its mind. That happened because the stakes were concrete, the affected interest was broad, and there was a specific sentence that would fix it. Take away any of those three, and the amendment does not happen. And the comparison to the rest of the season is instructive. The 15th Amendment's failure was not something a further amendment could fix, because the problem was evasion rather than interpretation. You cannot amend your way out of a literacy test administered in bad faith. The 14th Amendment's oscillation between expansion and contraction is not amendable either, because the disputed words are open-textured and any replacement would be too. Pollock was fixable precisely because the obstruction was technical. A classification rule can be rewritten in one sentence. A background principle or an apparatus of evasion cannot. So the 16th Amendment is a lesson about which constitutional problems have amendment-shaped solutions, and most of them do not. And there is a counterfactual worth entertaining briefly, because it clarifies the stakes. Suppose the amendment had failed, the corporate excise of 1909 would have remained, and Congress would presumably have kept grafting around Pollock with increasingly elaborate structures. Some of those would have been struck down, some sustained, and the resulting system would have been arbitrary, complex, and narrow. More importantly, the revenue ceiling would have stayed low. The federal government's capacity to fund anything at scale, in wartime or otherwise, would have been sharply limited by an 1895 reading of an 18th century classification rule. Whether that would have been better or worse is a political question this show does not take a position on. That it would have been enormously different is not in doubt. One more practical note. because it changes how you read the tax debates of the last century, because the court held that the amendment conferred no new power. The constitutional ceiling on federal income taxation is essentially the same ceiling that applies to any exercise of the taxing power. There is no special 16th Amendment limit to find, which is why constitutional challenges to income taxation almost never succeed, and why the serious arguments about tax policy are made to Congress rather than to courts. The venue question was decided in 1916. That is unusual. Most of the provisions in this season generate continuing litigation about their meaning. This one generated a decade of it and then went quiet, because there was very little left to contest. One last observation, and it is about how to read this whole season. Most episodes here find a gap between what a provision promises and what it delivers, and the gap is usually a disappointment. The words say more than the doctrine does. The 16th Amendment runs the other way. Its words say almost nothing. They are technical, dry, and narrow, and they promise no principle at all, and what they delivered was the fiscal foundation of the modern American state. So the lesson is symmetrical with the rest of the season, just inverted. You cannot read a provision's importance off its language any more than you can read its effectiveness off its language. Both depend on what the provision touches, and the driest sentence in the Constitution can turn out to be holding up the most. That is the sample. A full Amendment 16 season on this show would take the strands in turn, the direct versus indirect distinction in the original Constitution, and why apportionment was written in the Civil War income tax and the case that upheld it Pollock in both of its 1895 decisions, and the reasoning that looked through income to its source the 1909 corporate excise. As a workaround, Brushaber and Stanton in the holding that the amendment conferred no new power, and the long interpretive fight over the single undefined word, income. One question per episode, each anchored in cases we verify, not cases we remember. A word on how this show works. Everything you just heard is legal and historical education, not legal advice, and nothing in it is tax advice of any kind. And every case in it is real, named, and verified against the public record before it was written. Pollock versus Farmers Loan and Trust Company in both of its 1895 decisions, Brushaber versus Union Pacific Railroad, and Stanton versus Baltic Mining Company. Their holdings are described here rather than quoted, and where we summarize rather than quote, we say so. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.